Mr. Fantera, I believe that we are in the middle of your, well, actually, it was Miss Battles. Read direct.
Yeah, I think Miss Battle was cross-examining Miss Charles.
That's correct. Miss Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to the terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Miss Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law and landlord-tenant acts.
That's not, we're not under common law anymore, ma'am. And that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
well,
not.
That sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're trying to group me in with them, and that I am not.
Before we even get into the testimony, let's pause right here because this case is already waving every red flag imaginable. What you're watching isn't just a landlord-tenant dispute. It's a full-on collision between courtroom reality and someone who genuinely believes confidence can replace the law. Judge Washington is stepping into a situation where the defendant isn't just challenging the facts. She's challenging the entire legal framework itself. That's important because courts don't run on vibes, beliefs, or internet research. They run on statutes, procedures, and precedent. And when someone refuses to operate inside that structure, it almost always ends the same way. What makes this case especially explosive is that we've seen this exact defendant before, complete with courtroom chaos and distractions. This time, the distractions are gone, but the mindset hasn't changed. And as you're about to see, once the judge realizes this isn't confusion but defiance, the tone of the courtroom shifts fast. Stick around, because every argument she makes only digs the hole deeper.
Well, whatever you're using as your basis is still not correct. It is not the law.
It's still under MCL and it's under the Landlord-Tenant Act.
Overruled.
My objection is overruled, Your Honor?
No, the objection is sustained. Her question, it cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was rescinded?
That's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
my ruling, I'm not arguing with you anymore about it.
Right. It's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to asking these questions. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No. A notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there a proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You cited a statute that I actually need to look up. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.5716.
This is where courtroom experience, or the lack of it, starts to matter. The judge is giving Miss Battle the floor, but what's really happening here is a test. Judges watch closely to see whether someone understands procedure, relevance, and burden. Miss Battle believes she's about to expose some fatal flaw in the case, but her questions immediately drift into vague legal jargon without grounding. That's dangerous. Courts don't reward creativity, they reward precision. Notice how quickly the opposing attorney becomes alert. He knows exactly where this is going because he's heard these arguments before, claims about waivers, rescission, and rights that sound powerful but collapse under scrutiny. This moment sets the tone for everything that follows. Instead of narrowing her focus to the actual issue, non-payment of rent, she's trying to put the entire lease itself on trial. And that strategic mistake is about to cost her badly.
All right, Miss Charles, please, her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's now, again, she's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay. That's fine. I didn't cite an exact statute, but I appreciate your objection.
This is exactly why attention matters, because somehow, less than 2 minutes later, she's already contradicting her own words. What was stated clearly just moments ago suddenly gets rewritten in real time, as if the record doesn't exist. So before the story shifts again, let's slow it down, rewind the tape, and remind everyone what was actually said, because the courtroom doesn't run on selective memory.
Right here is the turning point where the judge stops treating this like a misunderstanding and starts treating it like a pattern. When Judge Washington references sovereign citizen arguments, it's not an insult. It's an observation rooted in repetition. Courts across the country hear the same claims over and over. Common law supremacy, Magna Carta references, selective statutes pulled out of context. And when someone insists they're not part of that group while repeating every one of its talking points, the credibility gap widens instantly. The judge isn't accusing, he's diagnosing. And notice how Ms. Battle responds emotionally instead of legally. Rather than correcting the legal issue, she accuses bias. That's another classic move. But in court, feelings don't override facts. This exchange matters because once a judge identifies your arguments as legally unserious, every future claim you make is viewed through that lens.
I just said
An
MCL
objection
because
is
they're
the-
both under NCLs. Both proof of service and certificate of service are both under
No.
MCL.
No,
All right, well, everybody, so
You
let me make my ruling.
let's just okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service
okay,
is,
ask that
is
question.
not on the disposition. And just like she read on 657-16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no
It's,
there are no
it's-
such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
And-
No,
public.
we're not publicly.
Well,
Now,
you
what-
accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
object to it, I didn't say anything yet.
Well, I'm objecting because she asked Miss Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next
And
question.
she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth
Everybody,
before you
please
objected
just
me.
Let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not.
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because
This-
it's not, that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear.
Just
I
rest,
said either federally funded or get federal funds, which you do if you accept Section 8 and voucher.
This moment is critical because it exposes the core misunderstanding driving Miss Battle's entire defense. She believes that simply declaring a contract rescinded makes it so. But contracts don't work like social media posts. You can't just announce something and expect legal consequences to follow. The judge makes it crystal clear. Unilateral rescission isn't the law. There are processes, requirements, and consequences. And the biggest problem for her argument is factual, not legal. She never moved out. By continuing to live in the property, she affirmed the lease, whether she wants to admit it or not. Courts look at actions, not declarations. And at this point, the judge has lost patience because he's explained the same principle repeatedly. This isn't a debate anymore. It's a ruling, and ignoring it only makes things worse.
No, that's not true.
Why is it not correct? You had to think about it. Yes, it is correct. Because if you received any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are, do you?
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Ms. Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a federal registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that
not a
these are the
None.
requirements, hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts behind anything he's saying. He's just thinking it off the top of his head. I'm not getting a fair hearing.
Here's where terminology becomes the battlefield, and Miss Battle is losing it. She's fixated on the phrase, notice to quit, believing it's a procedural silver bullet. But eviction law is precise, and Michigan law clearly distinguishes between termination cases and non-payment cases. The attorney's explanation isn't opinion, it's statutory. A demand for possession is exactly what the law requires in a non-payment case. By clinging to the wrong term, she's essentially arguing against a straw man that doesn't exist. Judges don't reward technicalities when they're based on incorrect assumptions. And notice how calm and methodical the attorney remains. That contrast matters. The more confident she becomes in the wrong argument, the more isolated she looks legally.
Move on.
Move on. So, okay. Do you have a copy of the court establishing jurisdiction?
Who's that a question for?
Dawn, my plaintiff.
Your Honor, I object. The court's already said they have jurisdiction over the
The
property.
court said that she got jurisdiction because she said so, and that's non-judicial.
Okay. Ms. Battle, move on.
Move on to what? If I cannot have, this is not a fair hearing. And again, this is why
you're trying to turn this into.
I'm not trying to turn it into anything. I'm just trying to state the laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts. But for some reason are hindering me in this proceeding, and that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all of you all, because this is just not. And I told the Attorney General, and I told the IRS, and I did everything else because at the end of the day,
please move
all
on.
this is not right. And attorney
I'm going to be filing criminal proceedings against you for all these frivolous things that you're filing against.
This is one of those moments where confidence and correctness completely diverge. Miss Battle proudly cites a statute, believing it proves her case, but the irony is brutal. The statute actually confirms the opposing side follow the law. Judge Washington even walks through the language line by line, removing any ambiguity. This is why courts emphasize reading statutes carefully, not selectively. You don't just spot a keyword you like and stop there. Legal interpretation requires context, and once again, the record becomes her enemy. The law is written, the procedure was followed, and no amount of reframing changes that. At this point, the judge isn't just ruling, he's educating, and that's never a good sign for the person on the losing end.
That is frivolous, that's fine. But it's not. My
Well,
rights and
the
my
Attorney
rights are
General
not
said.
frivolous.
Please move on.
It's honestly, if I can't have a fair hearing, nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut, that would constitute as
cross-examination.
Battle, if
That
you're
would
not going
constitute
to
as
ask
the same
appropriate
type of
questions, then I'm
fault.
just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't
Well,
have a real opportunity to ask the questions. So at this point, like I said, I'm just gonna have to get the federal court involved and get the marshals, because I don't know what you all are gonna do in honor and with good faith. So I don't know. I'm stuck on what to do. The integrity of the court is
Something
questioned.
wrong with you. I don't know what that is, but you should seek some mental health. Because something's
sorry?
wrong with you. You have
You
a
said
mental
what?
You have a mental problem.
I have a mental problem. How?
The United States don't apply to you, and you get to make them up as you go along, like you know more than everybody else in the world. There's clearly something wrong with you.
No, what did I make up?
All of it.
What? Be specific.
Right.
No, be specific, because
No.
now you're lying on the record. This is perjury. I didn't make nothing up. 42 USC definitely applies to this case.
All right. I have
Jurisdiction is a threshold.
Ma'am, if you don't stop, I'm going to remove you from the court proceeding. So, Mr. Fantera, apparently we're not going to have a reasonable hearing here today because Ms. Battle feels as though the laws are very different for her as opposed to everybody else in the world. I'm not certain how to handle this going forward. You have submitted your documentation and she wants to argue stuff that's not law, regardless of my rulings. So therefore, I'm not sure what to do with respect to your case.
I would ask for a directed verdict. She hasn't said anything that is a defense to my action, and I submitted a proposed judgment this morning. There's rent owing in the amount of $3,432.42, court costs of $177 for a total of $3,609.42. We would ask for a judgment for possession with a writ after 10 days, and she can avail herself of whatever procedures she can in another court.
So you're saying that none of my objections is valid towards your claim?